Hello again, everyone. As you know, I'm Professor Robert Romano, and this week we're going to talk about risk management issues in the sports industry. We're going to cover a bunch of different topics. We're going to cover constitutional law issues, Fourth Amendment law issues. We're going to cover DRAM shop issues. We're going to cover liability issues. So there's a lot this week regarding risk management. I'm going to cover as many topics as we can, but just be aware that there's many more issues out there, especially in this area. What we're not going to touch on is some criminal liability. Criminal liability on the field, on the pitch, on the court, and criminal liability that within the arena or the venue itself. But beginning, we're talking about liability, specifically premise liability, since we're talking about facilities and arenas and the risk that is associated to both of these entities. Premise liability basically is a legal responsibility of owners of facilities to those who use the facility. Okay, so if you own a facility, work at a facility, manage a facility, you have a legal responsibility to those who come in and use your facilities, those who come to games, those who come to concerts, to the circus, whatever it is. It doesn't matter what it is. Once they are using your facility or on site, you are responsible for their health and safety and well-being. You have a standard of care, the duty or responsibility owed by the defendant to another. Okay, the standard of care varies depending on who is on your property. If they're a trespasser, there's a limited duty. Licensee, someone who comes onto your property with your knowledge, postman, delivery person, UPS person. They don't come on with your permission, but they come on. They have a license to come on your property to do their role. Your mail is going to be delivered. You know your package is going to be delivered. And then there are invitees. Those are the people who you owe the highest standard to, especially business invitees. Okay, so if you invite someone onto your property, you have a high standard of care. You must make sure that they are safe once they're on their property, especially if they're a business invitee, because you're getting an economic gain from them being there. Business invitees are on the premise with permission of the owner and bring some economic benefit to the owner. All right, so this is why the standard is so high. They're on there with your permission, and they bring you an economic benefit. You need to take care of them once they are on your premises. Some of the duties owed to an invitee from the get: you need to design your facility safely. And this is usually done in conjunction with the architect and builders, but you need to design a safe facility. Railings have to be the right height. Entrances and exits must be the right width. Vomitoriums must be safe and clear of debris, well lit. So you have a duty to design a safe facility right from the get. You also have a duty to warn. All right, if you're running a facility, you're the owner of a facility, you're managing a facility, you have a duty to warn of obvious dangers: soda spills, water spills, ice on the walkway. You have a duty to warn of these obvious dangers. Even though you can see them and it's quite obvious that someone's going to see it, not everybody will. So you have a duty to warn of any obvious dangers and of hidden dangers. Anything that's not seeable, viewable, you have a duty to warn your patrons who come onto your property. And you also have a duty to inspect. All right, so water spills or soda spills or beer gets tipped over, you have a duty to warn of it. Warn of this condition. You also have a duty to inspect, right? Reasonable inspection to discover dangers. So if you're owning a facility, you have to let your employees know they have to look around. They have to be aware. You have to have somebody go around checking, making sure that it is safe. Nothing's on the floor. The ketchup dispenser hasn't fallen over and there's ketchup all over the walkway. All right, so you have a reasonable duty to inspect, to discover any dangers. What is reasonable? I mean, that varies. How frequent, type of use, all this varies into what is considered reasonable. But if you know it's a high traffic area, you know if there's frequent people coming through and that things can happen, you have a duty to check pretty frequently, to inspect pretty frequently. You also have a duty to repair any dangers. Once something's broken, you have a duty to repair it. The time and the extent of the repair depend on what is broken. I mean, the extent of the repair. If it's going to take an hour to fix, you got to get it done. If it's going to take 3 weeks to fix, well, you have a duty to warn in the interim. All right, you warn of this danger in the interim until it is fixed. But these are all on you as the owner. You need to warn. You need to repair. You can't just let it sit there forever. You also have a duty to provide emergency medical assistance. All right, so you brought people to your facility. You know, some people may have heart conditions. You know, some people may have medical conditions. You have a duty to provide emergency medical assistance, especially on hot days. If your one is in a facility and it's 100 degrees outside, yes, you have a duty to provide emergency medical assistance. People are going to faint. People are going to fall over. People are going to get a heat exhaustion. You have to provide them water. You have to provide them care, emergency first aid. So you have to have all the staff on place, okay? And of course, you need to have an auto external defibrillator. That's most jurisdictions. That's the law. You have to have so many per the size of your building. Now, after you have all these duties, you have to take care of people when they're there. One of the biggest things you have to do is you have to keep people safe. All right, once they come to your stadium, you have a duty, you have an obligation to make sure that the people who are there are safe and secure. All right, I mean, there have been many instances in the past that have triggered different protocols that need to be put in place. The Munich Massacre. If you guys aren't familiar with the Munich Massacre, research it. This was an incident that happened in the 1972 Summer Olympic Games in Munich, Germany. At the Munich Olympic Games, 11 Israeli coaches and athletes were taken hostage during the Olympics. Right? The security was so lax at the Olympic Games, the terrorists just walked into the Olympic Village, dressed as athletes, carrying duffel bags full of guns, and took 11 Israeli coaches and athletes hostage. The tragedy was that all 11 were executed. All right, so this set stage the need for security at these big events. People are using them as platforms for their message. So you need to make sure that not only the athletes are safe, but everybody who comes to your facility is safe. And then this was amplified after the 9/11 attacks in both New York City and in D.C. You know, our nation changed. We became a little different. Our security was shaken. So this plays into the terrorist hands. The attacks on New York City. Now there's been rumblings that there could be attacks on stadiums at big ticket events, Super Bowls, World Series, Final Four games. So there have been alleged downloads of stadium information, stadium schematics by terrorist organizations. This set the FBI scurrying. But the fact that there also been unsuccessful attempts at other sporting events. Spain's soccer venue, there was an unsuccessful attempt, and in 2004 and 2005 there were both suicide bombings at large ticket events. So knowing this, you need to keep your athletes safe, your employees safe, and your business invitees safe. In the 1996 Summer Olympic Games in Atlanta, this was pretty much the first time on American soil, not the first time on American soil that there was inspections. All right, limited visual inspections of persons and bags. What they were looking for was contraband, alcohol, projectiles. Projectiles meaning things that can be thrown onto the court, onto the field, onto the pitch. So it was very limited visual inspection, but we here in the United States weren't used to this. And I was at the Summer Olympic Games in 1996, and people were really upset. They're like, "You can't inspect me. You can't look through my stuff. You can't pat me down. This is America. We have Fourth Amendment rights." But in 1996 Summer Olympic Games, they implemented a limited visual inspection of bags and persons, looking for these three things: contraband, alcohol, and projectiles. People were upset. They were upset until the bomb went off in Olympic Park. The bomb went off after the Ray Charles concert. There was a big boom. People were injured. One person died. After that, people were a little less leery, less vocal about the searches, but the searches were increased to now check for weapons. And again, this was one of the first times on American soil that people were searched. And this isn't too long ago. This was 20 years ago. In 2001, the Super Bowl between the Ravens and the New York Giants was affectionately referred to as the Snooper Bowl afterwards, because everybody who entered the stadium, their face was run through the FBI database. There was face recognition scanning. They're looking for known terrorists, known criminals. This was done without the people's knowledge. This was done without the fans' knowledge. This was done without their consent. People were upset. All right? Rightfully so. They were walking in. They didn't know that their picture was being taken. They didn't consent to their picture being taken and consent to their image being taken. And there was a great article written by Len Elmore entitling it "The Snooper Bowl," saying how could they do this? This is terrible. But everything changed in September of that year after the 9/11 attacks in New York and D.C., to the point where by 2006, at the Detroit Super Bowl that was held in Detroit, the Lions weren't in it. The NFL advanced the holographic face scanning techniques. All right, so after the 2001 bomb, 9/11 attacks, the world changed, and people were like, okay, gonna look for terrorists, I'm okay with that. Still a violation of the Fourth Amendment, but I'm gonna waive it. Okay, to the point where only 5 years later, they already had holographic face scanning techniques in place at the Super Bowl. In 2005, under the former commissioner Tagliabue, he implemented a mandated pat-down policy at all venues, at all stadiums. If you were the Detroit Lions, you had to implement a mandated pat-down policy. If you were the Philadelphia Eagles, you had to implement a mandated pat-down. And this was to check for IEDs, improvised explosive devices. All right, so the protocol was the screeners were to run their hands along the sides of the torso and down the spine. And the process involved touching, patting, or lightly rubbing. That's not my terminology. That's the NFL's policy. Touching, patting, or lightly rubbing. So this protocol went into place. It was mandated at all venues. Screeners are to run their hands along the sides of everybody's torso and down the spine, looking for IEDs by touching, patting, or lightly rubbing. Stadium and arena managers, security managers, general managers need to be aware of the legal issues involved in these pat-downs, because since the NFL implemented the policy, 3 lawsuits have been filed against the NFL, against the individual teams, and against the venues themselves. And these lawsuits involved the pat-downs. Are they a violation of your Fourth Amendment rights? The first question you need to ask on a Fourth Amendment issue, or any constitutional law issue for that matter, is there state action? What I mean by that, is the government involved somehow? If there is government involvement, then there is state action. So the question becomes, at these stadiums, is there government involvement? You may be sitting there thinking, well, no, it's a private entity. The NFL is private. The teams are private. It's a private entity, private venue. that there's no state action involved. There's no governmental action involved. Well, in reality, there is. Okay? Reality, there is, because of two main reasons. Probably more reasons, but two main reasons. Because if there is a police presence there, if there are police on site, then state action kicks in. And I know most stadiums, especially on game days, most arenas on game days, most venues on game days, they have police officers there. The second way state action kicks in is most of the facilities, most of the arenas, most of the venues have some form of public funding. All right, there's some public money involved. If the stadium received any form of public assistance, any tax money, then state action kicks in. You know, Jerry Jones talks about, I built this stadium by myself. No, he didn't. He got a lot of money from the government to build that stadium. Bob Kraft up there at the Patriots, tax dollars helped build that stadium. All right, so if there's any government involvement, state action kicks in. Okay, so the Fourth Amendment, applying the Fourth Amendment to searches of sports spectators must be based upon the finding that a government actor conducted the search. And that is true. I mean, if the government actor is there, if they're police, if there is tax money involved, then the venue has a government actor and your Fourth Amendment rights kick in. All right, plaintiff must allege that a state actor has violated a right secured by the Constitution and the laws of the United States. If they allege it, they'll win that. The U.S. Supreme Court has held that weapons pat-down searches, if you're looking for weapons, is a search within the meaning of the Fourth Amendment. All right, so the NFL is saying, well, we're just looking for weapons. We're just looking for IEDs. Well, okay, you are. You're right. You are. You're looking for weapons. But the case of U.S. versus Rogerman says, if you're looking for if you're patting down somebody looking for weapons, it's a search within the meaning of Fourth Amendment rights. Okay, so U.S. stadium managers, security managers, legal counsel for a stadium, legal counsel for a team, you need to be aware that these pat downs that most of the NFL has implemented and most other major properties have implemented are a search within the meaning of a Fourth Amendment search. All right, the Fourth Amendment, the U.S. Constitution, Fourth Amendment reads, the right of the people, you, myself, anybody, to be secure in their persons, houses, papers, and effects. Effects. Think about that word for a minute. What does that mean, effects? Does that mean a backpack? Does that mean a purse? Does that mean a coat? Yes. That's what it means. They're effects, what they carry with them. So it's the right of the people to be secure against unreasonable searches and seizures. This shall not be violated and no warrant shall issue but upon probable cause. All right, there needs to be probable cause in order to search someone. If you do not have probable cause, there is no right to search. And therefore, it is an unreasonable search and seizure. And if your stadium does this, you're setting yourself up for liability. The question becomes, what is probable cause? And, the argument I hear at a lot of the seminars I go to, well, we have to check people. We have probable cause that there may be something out there. No, you don't. You can't just blatantly search everybody saying, we need to search everybody because somebody may have something. No, you need probable cause that a specific person is carrying a specific weapon or is going to cause specific harm. It can't just be a blanket probable cause doctrine. Something may happen at our stadium, so we need to be careful. So we want to implement the pat-down policy. No. It needs to be specific. Probable cause is very specific. If you haven't taken criminal procedure yet, or if you haven't taken criminal law yet, I would advise you to, because it gets really into what the standard is for probable cause. But then most of the questions I get after the Fourth Amendment is, well, people don't have to come to the games. People, it's voluntary. They're coming to the games, they buy their ticket, it's a voluntary act. Well, you're right, it is a voluntary act, but there is this thing called the unconstitutional conditions doctrine. All right. Under the unconstitutional condition doctrine, you cannot prevent the grant of a benefit, in our case, entering a stadium, on the surrendering of a constitutionally protected right. All right. You cannot force someone to give up one of their constitutional rights in order to enter your stadium, in order to enter your venue, in order to enter whatever. If there's state action, you cannot make them give up a constitutional right. All right. So the burden isn't, well, you don't have to come. No, the burden is you can't do it. You cannot force somebody to give up their right. They can consent to it. That's fair. But you can't force somebody to give up their constitutional right. All right. So all these doctrines are important. State action, the weapons pat-down searches, the Fourth Amendment, the unconstitutional conditions doctrine, because they all played a role into the two cases that I had you read for this week. Sheehan versus San Francisco 49ers and Johnston versus Tampa Bay Buccaneers. In the Sheehan case, which was 2009, March 2009, the court kind of punted on it. I mean, I want you to read it. I want you to go over it. I want you to analyze it. But the court kind of punted the issue. All right, they said at this level, the NFL hasn't shown that there is a threat to public safety. All right, and that there's a substantial and real threat at stadiums. They haven't shown it. So what they did is they remanded the case back down. All right, for further investigation, further evidence. The NFL came in saying, no, we have a fear of terrorism. It can happen. But the court said, no, you need to show us more than you just have a fear. You have to show us that there's a substantial likelihood that something can happen in order to implement this pat-down policy. Read the case, analyze the case, see how the court kind of came to the reasoning, but then stopped short and then remanded it back down for more evidence. And that brings us to the second case, Johnston versus Tampa Bay Sports Authority. This was an interesting case because Johnston protested right from the get-go. I mean, read the case or analyze this case. Johnson never volunteered, never consented to the search. He protested at every level. He called in advance protesting he wanted his money back. He got to the stadium, he protested, but he had to give up his, told him about their unconstitutional condition doctrine, that you cannot do this to me. They forced him into the search. He never consented. But the court came out and said, yeah, you voluntarily consented to the pat-down by going into the stadium, and therefore no constitutional rights were violated. Read the case. Read that case very carefully. Tell me if you think the judge used logical, his opinion is very logical. I don't see it. His kind of jumps around. He jumps over the unconstitutional conditions doctrine. He says there's no state action, then says there is state action. He goes back and forth on his opinion. Read that case. Really analyze that case. All right? And then think about what you can do with this opinion. If you're general counsel or outside counsel for a venue, what can you do with this opinion? I mean, voluntary consent to a pat-down is you're waiving your constitutional rights. All right, but did Johnson really voluntarily consent? Or was he forced to consent? I mean, take this to the next level. Think about what you can do as a general counsel. Think about what you can do as stadium or security manager. To say, okay, we have this opinion where there's voluntary consent. How can we use this opinion to our benefit? How can I now take this opinion and advise my client, my venue, my facility properly? Okay? There's a lot to risk management in sports. There's a lot to it. There's a lot of premise liability. There's a lot of risk management. And then there's a lot of constitutional law issues. All of this comes under the guise of risk management. So I want you to think about it. I want you to analyze the Sheehan versus 49ers case, the Johnson versus Tampa Sports Authority case, and then see how you can use these cases to advise your clients properly so that they're not in violation of the Fourth Amendment. All right. A lot of the stadiums have mandated pat-down policies by the leagues. They're torn between mandated pat-down policies and the rights of their patrons in the Fourth Amendment. See what you can do to bridge the gap. Okay, thank you. There'll be I'll post part 2 to risk management. Please take a look at that. It'll involve whole different issues involving dram shop, liability for alcohol, that kind of stuff. Thank you.